And we think that that's a very important point. We don't believe that that quite is where the bill is today. We would like to continue discussing the issue with Ms. Capel and with the author. However, we don't think that we are there yet. The concerns on whether or not there is a variety of plans, our members are agents and brokers. We don't think that their role in this process is really being acknowledged because there will be a variety of plans that will be available through the exchange. We think that somebody still needs to help them make those decisions. So this whole pre-enrollment process ignores that advice and information that we think that agent and brokers can bring to the process. For those reasons, we're opposed at this point.
Okay, thank you. Any other witnesses in opposition? Okay, would you like to address some of the issues that were brought up during the opposition testimony concerning obtaining consent, warehousing the data?
Mm-hmm. And I'll let Ms. Capel speak to this also, but I think that certainly we're not interested in, I mean, the goal is to get as much good information as we possibly can. I think we understand that it may not be 100% up-to-date information, but I think that is still something where we feel that in that process of separating from an insurance company, there are notifications that go out, final bills, grace periods. Do you want to go back? And I think the hope would be that in that process there would be that final communication asking and letting the individual know that there was this other possibility, and that is the exchange, and getting their consent. And I do want to also just address the issue of the fact that this is trying to position a person, to give them information. It's going to be a new world for folks out there, and we want to get them to that door. We're not signing them up. They're not going to get a bill in the mail saying that all of a sudden they're enrolled for something, and that there will be that process as the entire system is set up that's going to help people understand, would they get a subsidy, where would they fit, where's their income, what plan would they perhaps want. And if they didn't want it, then of course they're free to still have COBRA or to do some other type of insurance as well. So it's really about trying to introduce people who will not be familiar in these first years to the exchange and its availability to them. Ms. Capel, you want to add anything?
Two things, Beth Capel, Health Access. Two things. First of all, we are respectful of the issues raised by the problem with warehousing consent. We think the amendments that are now in print go some distance to addressing that. If we have not fully addressed that, that's something that we're committed to trying to resolve. Secondly, the amendments that are in print require informed consent for the application to proceed. So not only is there informed consent for the information to be transferred, but there's informed consent for the application to proceed once it has gone to the exchange, so that you would, if you agreed that your information would be transferred, then you would have to further consent to undergo eligibility determination and actually enroll. So we think we've provided those protections, and we'll look forward to continuing to work to perfect the measure.
Okay, questions or comments from committee members? All right, Ms. Bonilla, you may close.
I would respectfully ask for your aye vote.
All right, we have a motion. We will call the roll.
The motion is due. Pass the Senate Appropriations. Evans?
Aye.
Evans, aye. Harmon? Blakesley?
No.
Blakesley, no. Corbett? Aye. Corbett, aye. Leno?
Aye.
Leno, aye.
All right, the vote is 3-1. We will place it on call for the absent member. Thank you very much. Assemblymember Torres, item number 24, AB 1275.
Good evening, Madam Chair and members. Assembly Bill 1275 will make it clear that redevelopment agencies cannot delegate their authority or decision-making power to a person, and would allow a court to find a contract null and void if it violates the community redevelopment law. Redevelopment agencies can seek validation of redevelopment plans or amendments in the courts. The public only has 60 to 90 days to challenge a redevelopment agency's validation suits, depending on the activity being validated. This short time does not give the public enough time to challenge an RDA's actions before they are validated. In a recent case in Southern California, an RDA entered into a contract with a developer that required the RDA to pay 100% of the project tax increment to the developer, and the RDA failed to fulfill its affordable housing obligations. Although the redevelopment agency plan was validated by the courts, it was later found to be illegal. I believe this is an example that provides a strong argument for the need for this bill, and I am concerned that this may not be an isolated case, and the short statute of limitation to challenge the validation actions may result in losses to taxpayers and abuses by RDAs. Assembly Bill 1275 is not intended to jeopardize the activities of RDAs that comply with the community redevelopment law. This bill would only affect the bad actors that violate the CRL and grossly abuse their authority. And I am willing to work with the opponents to clarify that RDAs can delegate authority to staff and act on behalf of the board.
All right, thank you very much. Let's go to witnesses.
Christine Mittenham, Western Center on Law and Poverty, and one of the co-sponsors of this legislation. AB 1275 for us is another step towards reforming the problems with some of the bad actors in the redevelopment agency. Curbing the misuse or the unlawful use of their housing funds. That's our goal, of course, is to ensure that those funds are properly funded. As the author said, the redevelopment agencies are permitted to ask the court to validate the contracts for the agencies using the validation process, particularly with contracts that have major fiscal obligations. The validation process can result, as it should, in contracts that are, quote, forever and finally binding. And that is, of course, whether or not the contract was lawful or not, whether it went beyond the jurisdiction of the agency. AB 1275 gives the court the authority to declare null and void that part of the contract that is unlawful. And the author described one of our cases, which is amongst a number of them, where we have had to watch an agency with a validated contract go on for a matter of 20 years. This was our suit against the Fontana Redevelopment Agency. The contract with the agency was solely between the agency and one developer. All 100% of the money, contrary to redevelopment law, 100% of the money was allocated to the one developer. We've had 20 years of experience of that, those deposits. That contract is currently $1.3 billion is owed to the contractor. Approximately $900 million of it is the result of his interest rate on that debt, which is at 15.5%. We want to ensure that we don't see more of the kinds of things that we've seen in Calexico and a number of other redevelopment agencies. We want to ensure that the agency does not delegate to this one person all of this power of being able. The agency cannot enter into a contract unless for further debt, for an extension, for eminent domain, any of these kinds of things, unless the contractor agrees to it, or excuse me, the developer agrees to it.
I need you to wrap up.
Okay. Simply conclude that what the bill is intended to do is to strike those parts of the contract which are unlawful. And obviously, there's severability clause in the various contracts, so it doesn't do anything to the validation statute. That stays in place, and it would not nullify the entire contract.
Thank you. Any other witnesses in support? Witnesses in opposition?
Madam Chair, members, Hugh Bauer on behalf of the California Redevelopment Association. Well, this bill sort of presupposes that there is much of redevelopment beyond this year, but assuming that there is, we must respectfully oppose the bill. We recognize that the facts in the Fontana case are egregious and indefensible. However, the provisions of the bill seem to go beyond solving just the problems in the instance of that case. Section 1 of the bill, as the author noted, prohibits redevelopment agencies from delegating authority. RDAs, like every other unit of government, frequently delegate to executive directors, staff, routine determinations, contracts, essential functions running an agency, and we feel this would hinder agencies' ability to do that. Section 2 of the bill then specifically authorizes the amendments of contracts, but we feel this is unnecessary, as the authority to amend a contract is inherent in the ability to make a contract. However, if Section 1 is interpreted that says that they can't delegate, then it sort of seems inconsistent. The second part seems inconsistent with the first part. And finally, in Section 3 of the bill, it puts into the question, the fundamental question of municipal finance. The bond market is already skittish for local bond issuance, given the uncertainty of the economy, not to mention this bill and other legislation this year. And so it seems the legislature is again putting into question municipal bond authority. Under this bill, borrowing costs to local government would get more expensive if they're able even to sell bonds at all. I'd like to point out the comment that was made in the Senate Governance and Finance analysis, which described this bill accurately, in our opinion. Said AB 1275 injects unnecessary uncertainty of what might have into what would otherwise be reliable decisions. Bond purchasers and other agency creditors, the analysis notes, will, and not may, will shy away from redevelopment projects if their investments may be subject to unpredictable legal challenges even years later. I just want to mention that the Redevelopment Association has always been committed to reasonable reform. We've been committed all this year. As far back as 1992 and before with AB 1290 and other legislation. We're willing to work with the author and sponsors on this bill, but as it's drafted now, it's fairly, if not completely, unworkable. With me here is Brent Hawkins, General Counsel to the Redevelopment Association, to add anything or answer any technical questions.
Yes, the most problematic part of the bill is the part that creates an exception to the validation statutes for redevelopment financial transactions. Validation statutes were set up to provide public agencies a means of establishing the foundational acts which are the basis for issuing bonds, so that they can tell people who buy agency or city or county bonds that the foundational acts that authorize these bonds cannot be challenged. And in the absence of those kinds of assurances, bond purchasers are reluctant to make the purchase. What this bill would do would be to create an exception applicable only to redevelopment agencies. So only redevelopment agencies would no longer have the benefit of the validation statutes, while other issuers would. And this is going to create an inequality in the market where redevelopment agencies are trying to compete to sell their bonds, which would be carrying more risk on account of this exception. They'd be competing with other public agencies selling bonds with less risk. And so it's going to create tremendous problems for agencies to sell their bonds. If they're able to, they're going to have to pay more in terms of interest because of the greater risk that's involved. And we think the language here just goes far beyond what's necessary to deal with the problems that were apparent in the Fontana case.
Thank you. Next witness. State your name and affiliation, please.
Yes, Roxanne Miller, representing the City Council, City of San Jose. We are opposed to this legislation for the statements just made by previous speakers. Thank you.
Okay, thank you. Any other witnesses in opposition? Questions, comments from committee members? All right. Would you like to close?
In response to the comments that this would make it impossible for them to be able to issue bonds, I think quite the opposite. I think through this bill will encourage RDAs to follow the law. And for as long as they are following the law, their contracts will not be null and void. And this bill encourages that. And with that, Madam Chair, I respectfully request your support.
Okay, thank you. I am in support of the bill. Anybody want to make a comment or a motion?
I am also in support of the bill. I will make the motion.
Okay. We have a motion. We'll call the roll.
The motion is due pass to Senate floor. Evans?
Aye.
Evans, aye. Harmon? Blakesley? Corbett? Corbett, aye. Leno? Leno, aye.
Okay, the bill has 3 ayes. We'll keep the roll open for the absent members. Thank you very much. Next, we have Assemblymember Hill, item number 25, AB 1280.
Thank you, Madam Chair and members. Given the lateness of the hour, I'll be extremely brief. The Chair has raised some issues regarding privacy concerns with out-of-state vendors in this bill, and I've committed to the Chair that I will work with her and the staff to reconcile these issues that can be addressed as the bill moves forward, and that the bill would be held on the Senate floor until those issues and concerns are addressed.
Yeah, and I do want to make also very clear on the record that we have talked about this, and I've received your commitment that we're going to work on the privacy concerns and that it will not be taken up for a vote on
Correct.
the Senate floor until we've reached an agreement, and I reserve the right to bring this back to committee for hearing, and in most likelihood would do so prior to any vote on the Senate floor.
That's my understanding, and that's the agreement that I made with you earlier today.
Good. I think that's a reasonable way of approaching this. I think we are at the point where we could reach some agreements about privacy concerns that could allow the bill to move out of the Senate. But I want to be able to take the time to make sure that we get it right. This is a very important thing, I think.
And I want you comfortable with that, Madam
So
Chair.
go ahead and make a presentation, and I'll ask your witnesses to be brief.
Very quickly, the Federal Combat Meth Act contains a significant loophole that AB 1280 will close. AB 1280 will take information that consumers of pseudoephedrine products are already required to provide and utilize it to stop future illegal sales. Including this information in a database will help end the smurfing that goes on and keep pseudoephedrine products away from criminals, thereby slowing down meth production in California. Currently, this information is collected, but generally gathers dust in paper log books that do nothing to stop the criminals that it's intended to stop. I believe we can accomplish this desperately needed goal while still safeguarding important privacy protections of consumers. So with my prior assurances, I ask for your aye vote.
All right. Witnesses, very briefly, please.
Jim Gross on behalf of the California Pharmacists Association, which are the independent pharmacists. We've worked closely with the author and the sponsors for the last 2 years. We had concerns both about the privacy issues and about our ability to use the technology without having to spend additional dollars or time. We've been satisfied with that. We think that this will protect both the consumer and the small pharmacies, as well as create a system that is going to make a dent in the production of methamphetamine in California. We support the bill.
Madam Chair and members, Terry Thomas on behalf of CHPA, which is the trade association representing the U.S. manufacturers of over-the-counter drugs. And it is our trade association that is funding this program. California would be the 19th state to bring its retailers and pharmacies into NPLEX without any cost to the retailers. I will dispense with what I was going to say, but mostly what I want to say is that we have already added, and we're happy to work with you on dealing with the additional privacy concerns. We have already added a full list of privacy concerns to the bill, which the consultant has more than adequately captured on one of the last pages of the analysis. And it's very detailed what we've done to protect privacy interests and to safeguard the use of the information. Happy to keep working on that. The last thing I just want to say is that as manufacturers, we look at this problem and we think it's a very serious problem of meth production. But we realize that as manufacturers, we can't really do anything about meth addiction. That's really a medical problem and a prevention and treatment problem. We can't really be law enforcement cleaning up the meth labs, et cetera. But what we can do, working together with our retailer community, is we can be at the front end and preventing sales of meth that go over either the daily or monthly legal limit from leaving our stores and then being turned into PSC, then being turned into methamphetamine. So this is a really honest effort on our part to try to do what we can, which is within our limits and our ability, and we ask for your aye vote.
Good. Let's keep working on it. Go ahead.
Hi, my name is Carlos Gutierrez. I'm with the Consumer Healthcare Products Association. I'll yield to what Terry mentioned. I've worked on this in a few other states, so if you have any questions later, I'd be happy to answer.
Great. Thank you.
Misty Johnson with the California Retailers Association, and also speaking on behalf of the National Association of Chain Drug Stores. I'd like to echo the comments made by Jim Gross on behalf of the Pharmacists Association, as well as those made by Terry and Carlos with the Consumers Health Products Association, and we ask for your aye vote.
Thank you.
Trent Smith on behalf of Rite Aid Pharmacies, which already utilizes this technology throughout the country. We ask for your aye vote.
Maureen Higgins representing Biocom and its over 500 member life sciences companies in support of the bill.
Tom Bond on behalf of Pfizer. We are in support of the bill.
Randy Pauk on behalf of Reckitt Benckiser, the maker of Mucinex, in support.
Christy Weiss on behalf of Johnson & Johnson and Merck, two of the manufacturers who would be funding the program.
Juan Thomas on behalf of California Medical Association in support of the bill.
Curtis Hill on behalf of the California State Sheriff's Association in support of the bill.
Any other witnesses in support? Witnesses in opposition? And again, keep your comments brief because we are going to continue to be working on this issue before it comes to the Senate for a vote.
Good evening, Madam Chair, members. Valerie Small-Navarro with the American Civil Liberties Union, and I've asked the sergeants to please pass out the LA Times and editorial and an AP article precisely on the points we're discussing today. I appreciate that the chair has asked and the author has asked to continue working on privacy issues, and they are some very significant privacy issues. When we are developing or California is becoming part of a law enforcement database, essentially, in another state where California's law actually doesn't extend to that other state, we are raising some very significant concerns. In addition, we're talking about medical information under the California Medical Information Privacy Act. I'm sorry, I garbled that due to the late hour, but under state statute, we have the requirement that before law enforcement can access medical information, that they get a search warrant. That is not in this bill. It needs to be added to the bill if we are going to allow law enforcement to have access to a national database. In addition, I would like to call your attention to the analysis. I think your staff went through very carefully and raised a series of concerns that I understand you're going to be working through. But I think some of these are not so easy to work through, and I would suggest to you that it is counter to probably the manufacturer's business model to actually comply with these questions. So I'm starting on page 9, and I'm just going to quickly tick through some of these questions. But it says lack of direct contract with APRIS. This is the non-California company in Kentucky that's going to hold all of these Californians' information. Then it says, does this bill raise enforceability issues? Does California have sufficient control over APRIS to adequately ensure the privacy of consumers' information? Should DOJ have the ability to choose the vendor of the database? I think this was last year's issue that was quite poignant. Who should have the choice of the database? Should it be the manufacturers telling the state of California, or should it be the DOJ who decides who to subcontract with? Do the privacy issues risk outweigh the potential benefits? You'll see the LA Times does not think so. I mean, very clearly the headline is no. They do not think so. So I think there's a series of questions here that need to be addressed very carefully, and I would suggest to you that the manufacturers probably are not going to be in a position to agree to those. So while we appreciate the efforts and the intent, I suggest to you that this is medical
information and deserves the strictest protection. And I'm not sure that that's what this database, the way it's been configured currently, sitting in a Kentucky database would do. So I'm very concerned.
Thank you. Next witness.
John Lovell with the California Narcotic Officers Association and the National Narcotic Officers Association, and I also have portfolio today to speak for the LA County District Attorney. All three groups oppose this bill because it doesn't work. When this methodology was first put forward in Kentucky by the Appriss Corporation and by all of the manufacturers who you saw here at this table, the promise was that this would reduce the number of meth labs. And that's real important because meth labs, independent of meth trafficking, create their own problems. They blow up. Children are exposed to them. And it turned out that the promise was false. In fact, Kentucky today has more meth labs than they've ever had in their history. All of the law enforcement groups in Kentucky who originally had some hope for this strategy have now rejected it as something that doesn't work and actually went to the Kentucky legislature seeking legislation to require a prescription for the sale of pseudoephedrine. That bill went nowhere. Why? Because Appriss and the corporate interests have a lock right now, and they're not going to let that one go. This is not a strategy that works. The other thing you will hear, the proponents changed their story at one point. They said, well, okay, we're not reducing the number of meth labs, but we're giving you leads. Well, again, out of Kentucky, Kentucky State Narcotic Officers Association said that the number of leads they got from this was insignificant. And even if this did provide leads, I would remind this committee that last week the budget wiped out the entire Bureau of Narcotics Enforcement. Those are the folks who would be following up these leads. So you have something that we know on the ground doesn't work. There's more meth labs today in Kentucky than there have ever been. You have on the ground something that isn't going to provide leads. We know that from Kentucky, and even if it did, the resources aren't here. Oh, by the way, and don't expect that police chiefs will be able to pick up the leads, because the other thing the budget did this last week, and many of you probably don't even know this, in the effort to extend the VLF funding, the mechanism that was used actually caused fiscal harm to police chiefs. They only protect 78% of the state, but they actually resulted in a significant loss of revenues. So who's going to follow up these mythical leads? Because this doesn't wipe out meth labs. This is illusory. I would urge the committee. There are serious privacy issues, but I would submit you don't even have to get to those issues, because this is not an effective way to go. And there are narcotic groups all over the country who feel very strongly about this.
Thank you. Other witnesses, please state your name and affiliation.
Ken Pogue for the Attorney General. I think that the staff analysis was very well done and captures very many of the Attorney General's concerns. I just want to point out a couple things very briefly. I appreciate the Chair's willingness to work and look at the privacy concerns.
Very briefly. We're beyond the time already.
Just to carry over on John's analysis of what has happened to Bureau of Narcotic Enforcement, I've raised the issue of our inability to find funding sources to chase the leads that would potentially be identified by this system. We now, if this cut to DOJ remains in effect, will not even have the cops on the ground to chase the leads at all. The second is just a question for maybe the Chair to address as you negotiate further on this bill, and that is, how long is this system funded for? Because if the system is not properly funded for an appropriate amount of time, it could fall on California to fund this to have it work. So it's just a question I've never had answered. Thank you.
Lenny
Mr.
Goldberg, Privacy Rights Clearinghouse. We appreciate your addressing the privacy issues. I will only say very briefly that we made any number of other proposals to the industry in negotiations on this, including going through the CURE system, including ways that would have much more public supervision than a private, proprietary, out-of-state, sole source contract that takes our data and God knows what it does with it. So, and you hear from Mr. Lovell that the program doesn't work, and that's what we've seen also. But any effort that we ask the industry to take, say, paying a fee to cover some of these costs, oh no, we could never do anything that restricts the widespread sale of pseudoephedrine except impose upon our privacy.
Okay, great. Any other witnesses in opposition? Okay, and I'll allow the committee to make any comments or have any questions they might, or ask any questions they might have, but I do want to be very clear. This bill is here because of the privacy concerns. That's the jurisdiction of this committee. Understand the other issues as well. But in fairness to the author, I felt that there might possibly be some ways to address the issues and the very serious concerns that were raised by the staff analysis, and I felt it's necessary to give us a little bit more time to do that. No outcome is guaranteed, none. But I do want to have the opportunity to try to address some of these issues that are very complex and I think worth trying to address. So I've given that courtesy to the author. I think the author understands the conditions that courtesy has been extended under, and that also there is no outcome guaranteed. It may not go to the Senate floor for a vote. It just depends on whether or not we can arrive at any kind of agreement that will allow me to say, go ahead and move it to the floor for a vote. So that's where we're at this point. Any questions, comments from the committee? Senator Corbett.
A couple things. Just a quick comment. I had an opportunity to speak to the Assembly member about this bill, and I want to thank him. He's a very strong advocate on every issue he works on, and I want to thank you for that. And I know this bill means a lot to you, but as you know, I'm extremely concerned about exporting information, private information, to another state, and using our state law to do that where the information will not be protected by our state law. I am glad that the chair is going to give you an opportunity to try to address some of those issues, because I know that clearly what you're trying to do is address a terrible issue, and that's the use of these drugs that are supposed to be used for a very good purpose, and to make sure that that convenience is there for individuals who really need this medicine. But for now, I will not be able to support the bill. The privacy issues are just too great. But Assemblymember Hill, I would like to ask, do you have any thoughts on how you would propose to protect the privacy of this information? Do you have any thoughts yet?
Senator, we'll be working with that with the chair to develop the exact method and how that could be done. So
okay, very good.
That's why we agreed to have the additional time.
I would love to hear about your progress as it goes along, and if we're able to address those issues, I'd be glad to reconsider my thoughts on the bill. Thank you.
Thank you.
Okay, then very brief close, and then I'm going to ask for a motion.
Thank you very much. I just wanted to respond to some of the comments that we heard today, which I thought were interesting, especially in terms of the privacy issues and talking about the medical information and the sharing of medical information. There's no medical information in this. The amount of data that's collected is the exact same amount of data that's required by federal law, which is the date of the transaction, the identification number that was presented, the agency issuing the identification number. I guess that would be California driver's license, the name, date of birth, and the address of the purchaser. And that's it. And the amount of pseudoephedrine that was purchased. No medical information involved in that. It's just strictly the information that's required by federal law. Interestingly, the LA Times article is now 2 years old, so I don't know if it still would hold up in that. But probably the more important part comes from law enforcement, which I think is a little interesting, because they absolutely have nothing in the works that could stop any sale of methamphetamine. This bill in 8 states currently that's moving forward. 8 states currently are saving every month 126,000 sales are being denied, and where those sales would wind up, no one knows. Kentucky was claimed that Kentucky has a problem with the bill, and it's not working in Kentucky, but the state legislature in Kentucky had an opportunity. The bill was there to repeal this, and they didn't repeal it. So obviously they find some success on that. In terms of the Department of Justice claims of who's going to follow up with the leads and how that's going to occur, well, who follows up with the leads today? I don't believe that members of the Department of Justice are going into a pharmacy looking through their paper logbooks trying to find who's been trying to purchase and who hasn't been buying and purchasing pseudoephedrine, because that's not time consuming. A database could give them a better opportunity. And also, just want to close with the fact that the state sheriffs, PORAC, and many county sheriffs around the state are supportive of this and look at it as an opportunity to address the problems that are created by the illegal sale of methamphetamine. So I respectfully ask for your aye vote, members.
And I think if I allowed Mr. Lovell to speak, he might note the existence of SB 315, which is authored by Senator Wright, that would require a prescription for sorry, I can't pronounce it.
Pseudoephedrine, but I believe that bill failed.
Products. It's in the Health Committee right now.
Oh, it's held in the Health Committee.
Prior legislation failed. Anyway, with that correction, we'll take that as your close.
Thank you very much.
I will ask for a motion again under the conditions that I've outlined previously. So we have a motion. We'll call the roll.
The motion is due. Pass the Senate Appropriations. Evans?
Aye.
Evans, aye. Harmon?
Aye.
Harmon, aye. Blakesley? Corbett? Corbett, no. Leno? Leno, aye.
All right, it's 3-1. We'll hold the roll open for Senator Blakesley to add on, and look forward to continuing to work with you on this.
Thank you, Senator. Appreciate it very much.
And give us a little bit more time. Okay, Senator Leno, you are presenting item number 11 for Assemblymember Gorel, yes, I believe. If you'd like to go ahead. All right, that's AB 560.
Yes. And
no
I will
opposition?
begin by saying that the author accepts the recommended amendment by the committee. Just brief history here. It was back in 1998 that then Assemblyman Cardoza authored a bill that allowed for architects, not unlike attorneys and accountants, to be able to form LLCs that had a 10-year sunset on it. I then authored a bill in 2006, which extended that sunset to 2012. We're coming up on that sunset date. Assemblyman Gorel's bill will, with this amendment, allow LLCs for architects to continue to form until 2019. I ask for your aye vote.
Move the bill.
All right. Bill has been moved. Very brief
Madam Chair and
comment
members,
from
Ralph
supporters.
Simone, representing the American Institute of Architects, in support of the bill. I'll certainly refrain from testimony given the hour, but I would like to compliment your staff for the extensive time that they devoted to reviewing the insurance claims data and helping us pursue a survey of architectural LLPs. I think those two efforts justify the extension of 7 years. So we support.
Always appropriate. Thank you very much.
Thanks, Ralph.
Any other witnesses in support? Any witnesses in opposition? Hearing none, would you like to close?
I ask for your aye vote.
All right. We'll bring it back to the committee. Any motions, comments? Oh, all right. The bill's been moved. We'll call the roll.
The motion is due. Pass as amended to Senate Appropriations Committee. Evans?
Aye.
Evans, aye. Harmon? Aye. Harmon, aye. Blakesley? Corbett? Corbett, aye. Leno? Aye. Leno, aye.
4-0. We will keep the bill on call for Senator Blakesley. Next is item number 12, AB 621, and I have a letter authorizing Senator Calderon's staff to present the bill. Mr. White.
Thank you, Madam Chairman and Senators.
And again, no opposition to this bill,
No,
so
ma'am.
brief would be better.
Brief is good. First of all, I'd like to take as authors amendments the amendments noted in your analysis. And under SB 621, rental car companies who enter into rental contracts with foreign drivers and provide third-party liability insurance will accept service of process on behalf of foreign renters in the case of accidents. AB 621 specifies and clarifies that when a car rental company accepts service of process for a car renter, that a new legal relationship, such as that of an agent, is not created, and the bill will protect California drivers, assist them and the state by making sure that insurance that foreign car renters purchase can actually be relied upon as intended.
Move the bill, Madam Chair.
All right, we have a motion. Supporters of the bill?
Thank you, Madam Chair, members. Nancy Peverini on behalf of the Consumer Attorneys of California. We are the sponsor of the bill. Thank the committee for its bipartisan support last year. We did send it to the governor. He vetoed it, but we've now removed all opposition. So it's one of those few rare instances where it's a good bill with no opposition. So we ask for your support. Thank you.
Okay. Any witnesses in opposition? Seeing none, would you like to close?
I respectfully ask for your aye vote.
All right. We have a motion. We'll call the roll.
The motion is to pass as amended to the Senate floor. Evans?
Aye.
Evans, aye. Harmon? Aye. Harmon, aye. Blakesley? Corbett? Aye. Corbett, aye. Leno? Aye. Leno, aye.
Thank you, Madam Chair and Senator.
All right. It's 4-0. We'll place that bill on call. Yes, Mr. Leno.
Have we taken up item 29, vote only, AB 1041?
We have not. I was going to do that when we, I guess we would do it now.
I'd make a motion.
Okay. We have a motion on item 29, vote only. This is Assemblymember Ma's bill that we heard last week.
The motion would be do pass as amended to the Senate floor. Evans?
Aye.
Evans, aye. Harmon? Aye. Harmon, aye. Blakesley? Corbett? Leno?
Evans, no.
Aye.
Sorry. Evans, no.
Aye. Leno? Evans, aye to no.
Aye. I'm aye.
Leno's aye.
Bill is
On call, 2 to 1.
2-1. The bill will be on call.
Could we open the roll then on 29?
I'm opening the roll on all of the bills. Well, just give us a minute to get organized. Okay, we will open the roll on item number 1. The vote is 1-2.
That motion was due pass to Senate Appropriations. Evans? This is the Dutton bill, yes.
No.
Evans, no. Blakesley? Aye. Blakesley, aye.
That bill is 2-3. That bill fails. Item number 2, AB 143.
Blakesley? Aye. Blakesley, aye. Corbett? Aye. Corbett, aye.
Vote is 5-0. That bill is out. Item number 3, AB 212.
Corbett? Aye. Corbett, aye.
The vote is 5-0. That bill is out. Item number 4, AB 267.
Harmon? No. Harmon, no. Blakesley? No. Blakesley, no. Corbett? Aye. Corbett, aye.
The vote is 3-2. That bill is out. Item number 5, AB 360.
Blakesley?
No.
Blakesley, no. Corbett? Aye. Corbett, aye. Leno? Aye. Leno, aye.
The vote is 3-2. That bill is out. Item number 6, AB 361.
Harmon? Aye. Harmon, aye. Corbett?
The vote is 4-0. That bill is out. We need a motion on item number 7, AB 424. We have a motion. Call the roll.
The motion is due pass to Senate Appropriations. Evans?
Aye.
Evans, aye. Harmon? Aye. Harmon, aye. Blakesley? Aye. Blakesley, aye. Corbett? Aye. Corbett, aye. Leno? Aye. Leno, aye.
The vote is 5-0. That bill is out. The consent calendar is on call. Go ahead, call the roll.
Harmon? Aye. Harmon, aye. Corbett? Aye. Corbett, aye.
Consent calendar is out 5-0. Item number 10, AB 469. Yeah, excuse me, I should have announced that. Item number 8 was pulled. Item number 9 was consent. Item number 10, AB 469.
Corbett. Aye. Corbett, aye.
That bill is out 3-2. Item number 11, AB 560.
Blakesley. Aye. Blakesley, aye.
Vote is 5-0. That bill is out. Item number 12, AB 621.
Blakesley.
Aye.
Blakesley, aye.
Vote is 5-0. That bill is out. Item number 13, AB 622. AB 622, item number 13.
Oops. Blakesley, no. Corbett.
Correct.
Corbett, aye.
The vote is 3-2. That bill is out. Item number 14, AB 687.
Evans.
Aye.
Evans, aye. Corbett.
Aye.
Corbett, aye.
The vote is 5-0. That bill is out. That one already failed.
Yeah.
Okay. That was on consent. Item number 17, AB 792.
Harmon, no.
The vote is 3-2. That bill is out. Item number 18, AB 1074.
Blakesley. Aye. Blakesley, aye. Corbett. Aye. Corbett, aye.
The vote is 5-0. That bill is out. Item number 19, AB 1151.
Evans.
Aye. Aye.
Evans, aye. Blakesley. Aye. Blakesley, aye. Corbett. Aye. Corbett, aye.
The vote is 5-0. That bill is out. Item number 20 was pulled. Item number 21 was on consent. Item number 22, AB 1215.
Corbett.
Aye.
Correct.
Corbett, aye.
Harmon would be no to aye. Blakesley, no to aye.
Harmon, no to aye. Blakesley, no to aye.
The vote is 5-0. That bill is out. Item number 23 was pulled from calendar. Item number 24, AB 1275.
Harmon. Blakesley.
Can
we pass on that just for a moment?
Sure. I haven't announced the vote, so we'll leave that one on call. Item number 25, AB 1280.
Blakesley, aye.
The vote is 4-1 on that bill, and that bill is out with the conditions that I previously outlined. Item number 26, AB 1396.
Corbett.
Aye.
Corbett, aye.
The vote is 4-1. That bill is out. Item number 27, AB 1403.
Blakesley, aye. Corbett.
Aye.
Corbett, aye.
5-0. That vote is 5-0. That bill is out. Item number 28 was on consent. Item number 29.
Blakesley.
AB 1041.
Blakesley, aye. Corbett.
No.
Corbett, no. 2 ayes.
Okay, the vote is 3-2. That bill is out.
No? Yeah, 3-2.
Okay, item 1275 is on call. Item 24, AB 1275 is on call. We'll call the roll.
Harmon. Blakesley.
So the vote is 3-0. That bill is out. All right. We are concluded. Good job, everybody. That was a marathon hearing. Thank you very much for all your cooperation. We're adjourned.